Please, your lordship.
Yes.
Lordship, I beg for listing of a criminal petition, lordship. The matter was last listed on 2022, lordship. Since
When do you want?
I want it on 21st, lordship.
21st.
Yes, lordship.
All right. Okay.
Obliged, lordship.
Wait.
Okay. Yes.
May please, your lordship. I'm praying for listing of the anticipatory bail application on tomorrow, my lord.
Tomorrow, probably possible. Okay. Okay.
Deeply obliged. May I please, your lordship? Lordship, I pray for listing a transfer petition criminal on
When?
tomorrow, lordship. Lordship,
Tomorrow,
the
not
matter was
possible.
last posted on day before yesterday.
Tomorrow not possible. Next week, any dates. You can
Lordship,
take from.
Day before yesterday, the matter was posted, but as there was a division bench, the matter could not be reached. Now the matter is fixed on trial court on Tuesday,
No, tomorrow not possible.
Monday. Deeply obliged, lordship.
May I please, your lordship? Lordship, I beg to mention a motion matter for listing, lordship. This is
When?
anticipated. Lordship, it was listed last August 22/4
When do you want?
for Monday, lordship.
Monday? Probably possible.
Wednesday, 22nd.
Both. Obliged.
Madam, may I pray for listing of a bail matter, anticipatory bail, on Monday, 20.
Monday, a lot of matters. Any other date?
22nd.
27.
May I please, Lordship? I beg to mention for urgent listing a anticipatory bill, Lordship. Here, Lordship, we have already filed a bail, Lordship. It was
When
registered
do you want?
tomorrow, Lordship.
Tomorrow not possible.
Both the petitioners are husband and wife. They have a minor children at home.
Maybe.
22nd. 22nd.
Monday, Lordship, Monday.
Monday, a lot of matters. Your matter may not list. Monday not possible.
Lordship.
May it please, your lordship. Lordship, I beg to mention item number 7, lordship. Lordship, kindly adjourn this matter for 2 weeks, lordship.
Why?
Lordship, today there is some difficulty, lordship.
Seven.
On the appeal being made by Miss
And Dekarajan, lordship.
Learned Counsel appearing on behalf of
Mr. Wiseman, lordship.
Learned Counsel for the accused. Let's list the matter on.
After 2 weeks, lordship, any day.
After 2 weeks, when you have filed this petition?
I filed this petition.
This is the 24 matter, my lord, for bail hearing, LCR receipt, my lord, scan copy receipt.
And that's all right, but the direction of Supreme Court in Swatendra until case. Bail application has to be disposed of within a short period. If we adjourn the matter for 2 weeks. After 1 week. So you have filed a petition on 18th of March, 2 months already elapsed. So in contravention of the direction issued by the Supreme Court, we cannot adjourn the matter day after day.
Yes, lordship. So, lordship, kindly,
Probably
after
1 week. Suggest on next week.
24.
much obliged, lordship.
24.
May I please, your lordship? Lordship, I beg to mention for listing of a criminal appeal on Monday.
Monday not possible.
On 24th.
Tuesday or
Tuesday.
Wednesday, any day you can.
Tuesday.
Okay, Tuesday.
Lordship.
21st.
May I please, your lordship? Lordship, I beg to mention for listing of a bail application for bail hearing on Tuesday.
Tuesday, okay.
May I please, your lordship? I pray for listing a bail application tomorrow. My lordship, they are the owner of the track, but
No, not possible tomorrow.
22nd.
Monday.
20. Because they are the owner of the track, apprehending
No,
the
maybe 20 possible. Tuesday or Wednesday, any that you can take.
20 not possible.
20,
22nd.
20 we have refused some of the advocates already. 20, no.
On 22nd,
May I plead your lordship, I beg to mention an IA in criminal appeal, your lordship.
When?
In Tuesday.
Tuesday possible? Okay.
Oblige, your lordship.
May I please, your lordship. I beg to mention item number 19. I am for legal aid counsel, lordship. In this matter, lordship, we have to receive some record also, lordship. You will come after 2 weeks.
9.
19.
Oh,
Why?
19.
2 weeks, why?
Because, lordship, I have to receive some more records, lordship. I am just
You have to
Thank-
receive?
no, not yet received.
What?
Lordship, some petition, memo of appeal, lordship, etc. Lordship, I am just engaged as a legal aid counsel, lordship.
When?
Engaged at 2020.
20.
Yes.
20 to me, it is an
In this
yes,
AV,
normal validity of this is 1 year.
But valid, but case was engaged to me, lordship.
Item 19.
1990.
okay, on the pair being made by Mr. A.U. Ahmed, learned legal aid counsel, registrar list the matter on COVID suggestion that the person is behind the bar for more than 6 years.
Yes. Punishment is 10 years. Next week, any date.
On 28. Tuesday.
Yes.
28.
Yes, on 20.
May I please, your lordship? Lordship, I am praying for listing of a criminal appeal, my lord, on 22nd if possible, my lord. So, 24. Oblige.
Yeah, please, your
It
lordship.
means-
Lordship, I beg to mention for item number 28, I am praying for an adjournment, lordship.
28.
Lordship.
Why?
Lordship, my senior counsel is having some health issue, lordship.
Who is your senior counsel?
Mr. S. R.
Your name?
M.A. Chali.
Mr. M. S. Saleh, learned counsel
Yes,
for the
yes.
petitioner. Did you inform the other side? When
No,
Mr. N.K. Das is appearing for respondent number 2? No. Then we decline your request. We will call the matter.
May I please? I'm praying for listing of a criminal revision petition, my lord.
When?
Next Monday.
Monday, not possible.
On 27, next week.
27.
27.
May I please, your lordship? I filed an IA for immediate informant, my lord,
Ah.
in bail application. Bail application fixed on tomorrow, my lord. So I may be listed along with the bail application, my lord.
Already filed.
Possible.
Already fixed tomorrow, my lord.
No, no, you have filed.
Yes, already filed. Yesterday
Okay,
filed.
all right.
Obliged.
May I please, your lordship? I beg to mention for listing criminal revision petition, lordship.
When?
Monday, lordship,
Monday, not possible.
On 27, next week.
27. Much obliged.
27.
May I please, lordship? I would like to mention for listing of one criminal petition on 22nd, lordship.
22nd already lot of
On
matters.
27,
27.
27.
Obliged.
Well, I beg to mention one criminal petition and notice was issued on February, but other party has not appeared yet. The stay is required because next date is on 27th, my lord. So can it be on 24th?
Possible.
Okay.
Yeah, please, your lordship. The item number 29 was heard at length, some length by a coordinate bench. So it may be fixed with the appropriate bench.
29.
29.
29.
30. It was then after hearing that matter was fixed 52. I don't know 30.
So these are take matters,
Yes, lordship.
but without did you inform the other side?
Yes, lordship.
Mr. D.K. Mehdi,
Yes, lordship. I will improve him.
you inform him.
Yes, lordship, item number 29 and item number 30 is on same judgment. So after hearing at some length of item number 29, this item number 30 was tagged with item number 29.
Hmm. Rescisal is the matter before appropriate bench,
Okay.
29 and 30.
May I please, Your Lordship?
Yes,
My lord, I beg to mention item number 33, my lord. Kindly 33, kindly adjourn for 2 weeks, my lord.
why?
Why, my lord, some instruction is required from my client, my lord.
32,
33, my lord.
33. We will grant you 1 week time.
My lord,
Mr. Acer Sotomayor, Learned Counsel for the petitioner. Learned Counsel for the accused has tried for adjourning the matter for 2 weeks. However, 1 week is granted. Rescisal is the matter after 1 week.
God bless you.
My lord, few minutes back, I prayed for listing of this anticipated bail matter on Monday, but I had two petition anticipated bail matter.
Monday not possible, any date after Monday. Monday and Tuesday.
On Monday granted already, my lord.
Pardon?
I already mentioned for one, but it has, I had two matters on that day.
And one on 20, one on 22nd.
21.
One mentioned for 20,
No.
and another for 22nd.
No, both day it is connected, my lord. Connected case.
এটা আগতে মেনশন কৰা আছিল।
Actually, I have not mentioned the two. Actually, there is two. I mentioned for one only. Have not mentioned about one.
Monday to both of them. Monday not possible. Monday not possible.
Then
All the cases on 24.
Tuesday.
Tuesday and Thursday is not possible. So all the cases on 24.
24.
For 2 days or 14. Hearing.
May it please, Your Lordship.
Every party was it.
May I pray for listing of a criminal petition, my lord, last listed on 18/1/2024. Criminal petition.
When do you want?
Next week, my lord, any day
29.
before that,
Take it that from me.
27.
27.
Highly authorized.
Item for withdrawal. Item number 32.
May I please, Lordship, for order the with liberty lordship, the actually filed the criminal division petition, then wrongly filed the criminal petition lordship. They against the family court order.
Mr. N. Ahmed, Learned Counsel for the petitioner submits that he has the instruction to withdraw this petition and accordingly he tried for granting him permission to withdraw the same. There is accordingly allowed. However, the party will remain with him to approach this court again by filing appropriate petition.
Item 1, promotion.
May it please, Your Lordship, 439 of CRPC, and I have filed this petition for Kilwar Ali, and the number is Taizul Islam, Your Lordship. And who was forwarded on 2524, Your Lordship. And Your Lordship, page 8 is annexed.
They are already in jail azot in connection with another case.
No,
What is the
Lordship.
number of that case?
No, Lordship. Kindly go to FIR, Your Lordship, page 8. Page 8,
No,
Lordship.
in the hospital, we have mentioned that they were shown arrested here in this case on 3/5/2024.
On page number 15 of the forwarding report, Your Lordship.
No, I am referring to the cause title of your petition.
No, Lordship, this is typing mistake, Your Lordship. Typing mistake, sorry, Lordship.
Then you correct it, you file an IN, only thereafter we will hear you. Spread for by Ms. Medhi, learned counsel for the petition accused, raises the matter on Monday.
The Lordship,
By tomorrow, you file IA for correction of perspective.
Number 2.
This is 430 application, my lord. This is under section 44, 19, 20 and 406, my lord. The FIR at page 16. It is outed under the civil suit, my lord, related to civil matters. So there is a, my lord, dispute regarding, my lord, the possession of a, my lord, Hyundai hydraulic excavator. That was, my lord, leased out to the complainant by the accused by way of an agreement. The agreement I have also annexed, my lord. And that part, as part of that agreement, he has to pay 3 lakhs. The annexer, as at page 21, my lord. The type copy I have given at page 16. And itself in the prayer also, he is making the prayer that only for a prayer to recover his loss. And so far, this as far is concerned, the facts was that the person he took one excavator from me on the basis of the lease, which was I have taken from the another person on the basis of a lease. Again, the sublet. And as per that agreement, he has to pay 3,50,000 to me as a security and 1,460 rupees per day, 240 days in month hour. So he utilized the excavator for 50 days. So as per that agreement, he has to pay me 5 lakhs. And but he paid me 2,70,000 till today. And for that reason, I am not able to make the pace of the payment to the original owner from which I have borrowed. So accordingly, he has taken the possession from his query. So that is the allegation that the person, the original owner has taken the possession. So I am not the person, but he has not complied with agreement condition number 2. Lordship will get a page. This is agreement at page annex at 3. I am annex for page 25. It is started. As per the clause, my lord, he has to pay as per clause 2, 3,50,000 to me. And as per clause 4,
Agreement is at page number.
my lord,
Agreement is at page number.
page number it is started from
25, Lord.
25, my lord.
25.
Yes, my lord. The small agreement. So as per clause number 2, he has to pay the amount. And as per clause number 4, he has to pay the 1,460 rupees per hour. Total, my lord, total for 240 hours in a month. And that payment is to be made in every 15 days. So that is also he not complied. And as per the clause 10, that if any dispute arises not settled within 7 days, then the first party will have the right to take return of the machine from the second party. And the clause part 13, if any parties entered into this deed of agreement, violate, broke, and unable to maintain sanctity of the instant deed agreement, then the defaulter party will be liable to the victim party in accordance with law in force. The prosecution jurisdiction will be at Assam. But this was the condition. But this is out and on one of the civil agreement, my lord. This is the liability also civil. So I paid, my lord, the
Yes, Mr. Gogoi.
So let me interim, my lord. Otherwise, my lord, that is the agreement, my lord, that there is an agreement.
This is true,
If
my lord.
agreement, my lord,
That
then
can be only
monetary
for civil.
transaction, my lord, civil
Supreme Court already, my lord, settled some
liabilities analysis.
civil liability.
Heard Mr. P. So, learned counsel for the applicant and Mr. B. Gogoi, learned additional briefing for the state misconduct. Everything is in connection with Hamren PS case number
1 of
1 of 2024 under section 419 420 for the IPC. This application under section 439 or 438 services prepared by applicant Alok Dasgupta for grant of previous pay. The above noted case has been registered on the basis of one FIR lost by one Rahul Peron on
on 6
6th of January 2023. Is 23 or 24?
Actually, my lord, this is 24, my lord. He written as a 20, but case is registered on 24, my lord. But lordship will verify from the original his handwriting, my lord. It is page 21.
No, police didn't piece of register.
No, no, no. That here.
The essence of
Oh,
I think the FIR date is showing, so
Wrongly.
is that, person to an agreement dated 13 November 2023.
That should have been 24, my lord.
He had taken one Hyundai hydraulic excavator, 215 smart machine with serial number N66350026008, engine number 84893175. And he paid a sum of rupees 3,50,000. And therefore, he also paid a sum of rupees 70,000 on 29th of December 2023 to the accused. Thereafter, on 3rd of January 2024, the registered owner of the said machine has pulled back the machine from his quartz quarry at Arting Place, for which he suffered heavy loss. Mr. Mohanto, learned counsel for the applicant, referring to the annexure 2 of the petition at page number 24, submits that 24, 25, and 26 submits that the informant has violated the condition number 2,
24,
2, 4, and
10 and 13, my lord.
and 10 and 13, for which the original owner of the said machine has taken the possession of the same from the informant, and that the dispute is civil in nature, and therefore Mr. Mohanto contended to allow the petition. Mr. B.B. Gogoi, on the other hand, Mr. B.B. Gogoi, learned additional PP, on the other hand, submits that the dispute appears to be civil in nature. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed in the court. Then it appears that pursuant to an agreement dated 13th of November 2023, the informant of the case, namely Sri Rahul Teran, has taken one Hyundai hydraulic machine from the present applicant for excavation of quartz. And it is the contention of the learned counsel for the applicant that the informant has violated the condition number 2, 2 and
2, 4, and
2,
10 and
4, 10 and 13. 10 and 13. But having considered the submission of learned advocates of both sides, and also considering the nature and gravity of the offense and the punishment prescribed for the same, this court is inclined to allow this petition. It is provided that in the event of arrest in connection with Harmland PS case number so and so under section so and so, the applicant shall be granted. The applicant shall be released on periodic bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition. Shall not leave the jurisdiction of CJN Hamrend without prior permission. That's however this AB stands at disposal.
Query number 3.
May I please, your lordship? 438 application. The FIR is at page number 12, your lordship. Allegation under section 120B, 420, 397, 411 and 471. At page number 12, your lordship.
কি জিআরপি মানে
GSP official detail আসলে পারে।
So whether this present applicant has preferred any other petition,
This is the first application before your lordship, your honor.
but
The-
we have some another bail application we have dealt with in connection with this PS case.
lordship. But as per instruction of my client, he preferred this application for the first time before this honorable court, your lordship. And he's a employee of the railway itself, your lordship, and works in a shift basis, your lordship. And when the Alice, as Alice in the FIR, at that time he was the duty officer, your lordship. And for railway, your lordship, for loading and unloading any consignment, there is a different department, your lordship.
No, that's all right, but you have not legally carried consignment.
Lordship,
And it was carried in the power car. You are not entitled to carry this goods in the power car.
Lordship, I was only not the officer appointed in the power car. There are other officials also, your honor, lordship. And at that point of time, I was on duty.
Who will appear for this? Railway?
I will
JRP?
appear and I will cooperate with the investigation, your lordship.
GRP? Who will appear?
My lord.
Can you appear for GRP also?
GRP we can appear.
You can.
So I could apply.
Let the city come. So there is specific allegation against you.
Lordship, the search operation was conducted at prior to the lodging of the FIR, your lordship. On good faith, I have given my ID card and the phone number also. The time was very short at that time to cooperate with the investigation at that time only. Later on, I came to know that I was named in the FIR just because I was in the on duty.
We will peruse the case area. Gogoi?
There are other
CDN?
officers.
Diary
Your Honor.
requirement.
CDN?
24.
Much like.
Item for admission, item 4.
By last order, my lordship, call for the report and the case there, my lord. status of Dhula PS case number 196 and case diary of Dhula PS case number 370.
In this case, my lord, FR submitted.
Yes, ma'am, that I have also verbally made that statement that in connection with the same case, one FIR has been submitted, then again, the second FIR was lost. Here it is a case for passing of the second FIR on the basis of the same.
No, the number may be separate then.
No, number is separate, case number is separate, but regarding the same cause of action, two FIR was lost, my lord. That is my case, word.
Now it is lot 373. 21.
So 196, my lord, the same allegation was made in Dhula PS case number 196. And my lord, my learned friend has just stated that in that case, final report has been submitted. The contents of the.
Gogoi, you received the status report.
No, my lord, that instruction we received that FIR number and that, my lord. that
In
is-
both the cases,
No, one case, my lord, that is 373.
FR submitted.
Yes,
And what about this 196/21?
so that, yes, my lord, 196, my lord, I am sorry. This
Like,
is 196.
in
Dhula PS
196,
196, 21.
In that case, FR submitted.
FR submitted.
And in
Under
connection with 373?
373, we have no instruction, my lord.
No, on the other day, we have directed the then additional PP to obtain instruction in respect of both the cases.
No, here we have only one, that is 196.
So your pair is for causing the FIR of this 373.
373, my lord.
373.
Because with this regarding the same cause of action, the second FIR is made, my lord.
Gogo, you produce both the cases.
My lord, that
Third, Mr. Ayush Sodhari, learned
373.
counsel for the petitioner, and Mr.
this one go.
BB Gogoi, learned additional people for the state respondent. Mr. Gogoi, learned additional PP submits that he has received instruction in connection with Dhula Police Station case number 196 of 2021. And as per his instruction, the IU has completed investigation and returned the case in effort. But he has not received any instruction in respect of Dhula PS case number 373 of 2021. Accordingly, it is provided that Mr. Gogoi shall produce case diary of both the cases.
That
Before this court
196,
on
lordship, 196 will not come because FIR submitted.
produce the case diary of Dhula PS case number 373 of 2021 before this court on when
Yeah, the Dhula. 29, yes.
29. Further, it is provided that registry shall call for the record of Dhula PS case number 196 of 2021 from the court of Learned Chief Judicial Magistrate Dorong, Mangoldoi. Yes.
Hello. Criminal petition has been prepared against the impugned order dated 31st 3/2022 passed by the Learned Court of Petitioner Session Judge Kamrup Romia in connection with criminal revision petition. number
Where is that
40.
impugned order?
Impugned order,
145.
my lord,
145.
77 is, my lord, annexure 12.
So whether we have called for the record?
No, my lord, yet to be called for. Yet to be called for, my lord. If this honorable court deems fit, then it may be called for.
Can we dispose of the matter without perusing the record?
Yes, ma'am.
Heard Mr. M.S. Ale, learned counsel for the petitioner, and also heard Mr.
IC data.
I.C. Deka, learned counsel for the respondent
Private
number 225, and Mr. P.D. Gogoi, learned additional PT for the respondent number 1. It is submitted at the bar that the record from the learned court below has not yet been called for. And perusal of the record is necessary to dispose of the present application. Accordingly, it is provided that registry shall call for the record of criminal revision petition number 45 of 2019 from the Court of Learned Additional Session Judge Ramia Kamrup. And also the record of case number 67 of 2019 under section 145, 146 from the Court of Learned Executive Magistrate Ramia. Fix the matter on.
Or June.
In interim maybe continue, my lord.
Till next date, interim order pass earlier shall continue.
Highly urgent.
And number 6.
May please, your lordship. This is an appeal against the dismissal of the complaint case under 138. The sole ground is here. The court has come to the finding that authority letter is not due documents for maintaining the 138, my lord. On the basis of AC Upadhyay. They says that I don't have the personal knowledge. But my submission is, my lord, demand notice was issued by me, my lord. I am one of the authorized person of the. So at this stage, my lord, the notice may be issued. And if your lordship call for the records. Oh, your Lordship, my name has not been reflected because only in the leave petition, Lordship, we filed the wakalat number because the appeal was not there. Appeal was subsequently served, so we could not file the wakalat number. I have already filed the wakalat number in this case, so my name may be reflected in the record. Yes. In the pairing.
So leave was granted to you.
Leave was granted. Yes, leave was granted.
Appeal admitted.
No, appeal was not admitted. It's
Not
coming for the
admitted.
first time, Lordship. It's coming for the first time.
Heard Mr. K. Bhattacharya, learned counsel for the petitioner. And also counsel for the appellant, and also heard Mr. A. Tiwari, learned counsel for the respondent.
Number 2 and 3, Lordship.
Respondent number 2 and 3, and Mr. B.D. Gogoi, learned additional PT for the state respondent number 1. Judgment and order dated 24/3/2024. Passed by the learned Chief Judicial Magistrate. By the learned Judicial Magistrate First Class Kamrup M in Kamrup M Guwahati in serial case number 2499C of 2015 under section 198 NI Act. Is impugned in this appeal under section 378, which in bracket 4 of the Code of Criminal Procedure. It is to be noted here that by impugned judgment and order dated so and so, the learned trial court has acquitted the respondent number 2 and 3 in serial case number 2944C of 2015 under section 138 NI. Peruse the memo of appeal and the grounds mentioned therein. Let notice be issued returnable in 2 weeks. No formal notice is required to be issued since Mr. Tiwari learned counsel appeared on behalf of respondent number 2 and 3 and Mr. B.B. Gogoi learned additional PP appeared on behalf of state respondent number 1. However, extra requisite copy of the petition being furnished to them during the course of the day. Call for the presidential call for the record from the learned court below and list the matter on. So whether he was in jail Azot at the time of investigation.
Lordship,
আগত বেলত আছিলে নে? আগত
I was not aware of that. Lordship.
ডেফিনেটলি থাকিব সিটো
That might be
জাজমেন্টৰ
record
ডেটৰ
also.
পৰাহে ভিতৰত আছে না একেবাৰে অৰিজিনেলি সি এন্টিচিপেটৰী বিল লৈছিলে নে ৰেগুলাৰ বিল লৈছিলে ইনষ্ট্ৰাকশ্যন ল'ব লাগে কাৰণ তোমাৰ এই দিনকেইটাত ইয়াৰ লগত এইড হ'বতো সঞ্জীৱ 35 ৰেকৰ্ড 35 নেকি অৰিজিনেল ৰেকৰ্ডটো চাবি ৰেকৰ্ডটো মোক দিয়ক ছাৰে চাইছে
So he was arrested on 8/20/2011. Then he was granted bail on 16/3/2011.
8 days 9 days
9 days. And 2 months, 11 days.
yes
Any other point to argue?
Lordship, the days where thief was caught were different, Lordship.
Pardon?
As per the place where thief was caught, Lordship, as per version of PW 1 and 2, it was at Barohalia, Lordship. And as per PW 3, it is at LB Road, Lordship. And the prosecution has failed to prove the seizure list as well, Lordship.
Seizure list was exhibited.
It is an SGR, Lordship. As per PW3 Lordship, he signed a seizure list as per instruction of the police, and he didn't see the cylinder as well, Lordship. And as per PW4, nothing written in the seizure list. As per PW5, she put the thumb impression in the seizure list at police station, and she saw nothing in the seizure list, Lordship. Lordship, as per the PW 1 and 2, the story of two thieves was not established, Lordship. As per FIR, PW once stated in the FIR that one thief came, Lordship.
So there is a contradiction appears to be minor in nature, and the same were already considered by both the court below.
Lordship.
So any other point?
Lordship,
One is contradiction.
Lordship, prosecution did not examine the investigating officer, Lordship.
Yeah.
Lordship,
I am not examining.
no. IO means the investigating officer was transferred, and BW6 filed the charge sheet, Lordship. And at that time, the time he filed the search sheet, the investigation was already over, Lordship. That is why he was not the part of investigation, Lordship.
No,
That's-
maybe, but what is the purpose of examination of the IO?
Lordship.
That is mainly to prove the contradiction in the version of the witnesses.
Lordship.
Is there any material contradiction?
Yes, yes, definitely, Lordship. In Exhibit 2, Lordship, the seizure list, it was not specifically mentioned that the cylinder was recovered from the house of Munna Hussain, Lordship.
Mm.
One
No,
cylinder
maybe,
was,
but Munna Hussain deposed that it was recovered from his house.
but it was not specifically mentioned in the seizure list, Lordship.
Hmm?
And one cylinder was recovered from the house of Munna Hussain. The seizure,
Everyone includes the seizure list here. The seizure list is available in your record.
no, Lordship.
If Fuser or Fueless, Fuser or Economic.
The C cylinder was given in Jima, but the say Jima was not available on the CD, Lordship, as per PW6, Lordship,
That might be.
when he deposed the evidence, Lordship. He had not even seen the cylinder in the court, Lordship.
Seizure list, it is clearly mentioned, place of seizure. Munna Hussain, house of Munna Hussain. Veranda of Munna Hussain. Gardwan Potri. In the veranda of Munna Hussain. Okay. Gogoi, do you have anything to submit?
My lord, that
Only one empty
acquittal, this
cylinder.
is not fit
Cylinder
for
was
acquittal, my
recovered.
lord, I think.
So the period already he
Yes,
had
sir.
undergone.
That,
we will
that,
set
that
it.
may be considered, that may be.
Okay, we will pass the judgment.
Yes.
Heard this?
T4, Your Lordship.
Learned counsel for the revision petitioner and Mr. Gogoi, learned additional counsel for the state respondent. Argument concluded, judgment reserved.
Fourteen for hearing.
40.
It will extra whole. What তোমার কি কবল আছে?
May I please, Your Lordship? Lordship, in this matter, the respondent number 2 in person wants to appear before this honorable court, Lordship. And for the same, an application has been submitted before the registry, Your Honor. He's waiting in the lobby, Lordship.
What is the matter?
It's a defamation matter.
Defamation matter.
Yes, sir, let him appear.
Lordship.
My lord, if it would not cause any inconvenience to the honorable court, my lord, can this matter be taken up on next week, my lord? Any day? I have certain, my lord, personal difficulty today.
Otherwise, the matter is ready for hearing.
My lordship, ready.
Yes,
I'm Raktimava Swami,
yes.
respondent number 2 in the case number criminal petition 197/2016. I'm defined. My humble submission is that due to some
No, today.
circumstances, I came here to appear for myself in
No,
this
that's all
case.
right. You will appear. But today, he has prayed for adjourning the matter by 1 week.
So will not be in Guwahati. Actually, I am a Delhi-based person.
Acha.
Every time I am coming to Guwahati, and it is quite, I'm very upset, worried, and disheartened also. 10 years has been passed away without any concrete result. So that is basically a delaying process. They are going for a delaying and derailing the process of justice. So I should not allow the injustice to become the law. As injustice anywhere is the great
Oh,
threat to justice.
we are ready to hear the matter. But he has some inconvenience.
So last date on 19th March, 2024, the Honorable Court of Justice Maharashtra Nandi has categorically mentioned that no adjournment will be allowed in the next date.
My lord,
And-
he is a resident of Ulubari. He is a resident of Ulubari, Palton Bazar district.
But
That is written in the
yeah,
complaint
it is
petition.
my residence.
I don't know.
It is my residence,
Otherwise.
but sir, when the court has already, honorable court has categorically mentioned no adjournment will be allowed. After that, how can I go against the court order. Being a law-abiding citizen, it is my duty to inform you.
There is no such order.
So from on 19 March 2024, there is an order.
Yes, on that day, it has been mentioned that no adjournment shall be considered. But thereafter, another date elapsed on 9/4/2024.
That day it has not reached to the court because the item number was 61.
But if the other side is not ready to argue with the matter, we cannot compel.
It is the normal phenomenon, sir.
Normal
I
phenomenon.
regret.
What to do?
I don't want to disturb you also. I regret that. It is a normal phenomenon every time they are doing. That's why it has forced me to come to this floor of this
Mr. Das,
honorable
what
court.
is the inconvenience?
My lord, I have an appointment. My daughter's my lord, passport office 11:45. My lord, there is an appointment. My daughter is waiting there. That is why. Otherwise, my lord.
Okay, so I would like to submit that 20th because 21st I will be leaving for. I have the tickets and all. I can show the
28,
thing.
28.
24th I have to leaving. Before that it should be listed. So
No, your engaged counsel is also here.
I'm appearing for myself. She's assisting me. She's helping me.
We have strike off the name of the prison council, lordship.
Otherwise, my lord, if that is be the situation, my lord, I don't want to, my lord, my lord, disturb the normal process of the honorable court. My lord, I can start the hearing, my lord, today. But my lord, maybe I may not be able to complete, my lord, because there are certain witnesses which has to be placed before the honorable court. So if my lordship, then otherwise I can start the argument and then fix a date, keep it part heard, my lord, if that can be done, my lord.
No, instead of hearing piecemeal way, we have to finish on the same day.
My lord. On next Thursday, then, my lord.
Thursday.
Before 24th.
next Thursday.
24th I will be leaving from
Tuesday.
before 24th.
Holiday.
Thursday, holiday.
Maybe Tuesday.
Yes, Mr. Das.
My lord.
When?
First week of June, my lord. 6 June, my lord.
6 June.
6 June, my lord.
So when you will be coming back?
I will be coming back on 3rd.
3rd of June.
3rd of
Then 6th of June.
Okay.
That's agreed by learned advocates. No. Mr.
M.K. Das.
M.K. Das, learned counsel for the petitioner, and Mr. Raktiman Swami, respondent number 2 in person, and Madam Das, you are appearing here? Madam Das?
Yes.
For respondent number 1. Mr. M.K. Das, learned counsel for the petitioner, submits that he has some personal inconvenience today to argue the matter and price for listing the matter on 6th of June. Here is accordingly allowed. Recess shall list the matter on 6th of June.
I'm deeply obliged. Interim may kindly be continued, madam.
Okay. Till next that interim order pass earlier.
Deeply obliged, highly obliged.
15 and 16.
May I please, Your Honor? In item number 15, I am appearing as a legalate, as an amicus curiae, Your Honor. And in item number 16, J. Payang is appearing.
Mr. J. Payang on
So is the matter ready for hearing?
Yes, otherwise it is ready for hearing.
Then let Mr. Pine come, we will start after some time. After some time.
After some time, Lordship, I will convey.
Or at 2 p.m.
So I can continue if required. I
2
can
p.m.
start 2 p.m. At 2 p.m. Oh, bless.
Item 17.
May it please your Lordship. Lordship, although it's a jail appeal, subsequently I have preferred a application for bail and by the order dated 26 to 2021, the petitioner was granted bail. So from 28/9/2008, that is the date of judgment. So 2 years, 5 months he was behind the bar, and after 26 to 21, at present he is in bail. So although it's a criminal jail appeal, he is present in bail, Lordship. So Lordship, this is NDPS Act. He was convicted, 7 years RI and fine. And there is also a default clause.
So what is the quantum of contraband substance?
4.8 kilogram of
Ganja.
ganja. In fact, it's in a ganja plant. The allegation is that some ganja plant were there, but and subsequently they were also found some dry ganja leaves from the
Where? From the position?
from the this is house of the accused. Other persons are also there, but there is evidence that actually more other persons are there whose possession it was. That is also not very clear. So Lordship may kindly come down
But
to
the
here.
house belongs to the appellant.
The appellant's house is there. Allegation, Lordship, if Lordship sees that there are some and complaint was made by one of the Mahila Samiti, and the name of the Mahila Samiti was also not there. The only witnesses are the members of the Mahila Samiti. So they entered the house of the appellant, and they subsequently informed police that this is happening, and then police came, Lordship. Basically, that is the case. So Lordship may kindly come down to the Azahar.
So when the report was called for by order dated 8/2/2020. Lordship.
Otherwise, he was sentenced to undergo 2 sentences of 3 years and 5 years, 6 months. So if they run concurrently, your Lordship, the period could be over on 24th of February 2024. Since he was in custody during the trial also.
24 and 25.
24.
No, he may not be in the jail hazard also.
He may not be in jail hazard also.
But
Conviction
this
will-
appeal will remain. We have to dispose of in either way.
Yes, your Lordship. Otherwise, the issue is on a very narrow compass now, your Lordship. Because the allegation, if I may take your Lordship to the facts, it's a very small issue, your Lordship.
No, that's all right. But whether
I'm appearing as amicus.
amicus curiae.
Yes,
But for the respondent, this is a POCSO case also.
Yes.
Nobody's name to be nobody's name has been shown, Lordship.
Whether anybody appointed as a amicus, no, legal aid counsel for the respondent.
No, your Lordship.
Whether notice was issued or not.
Notice has
Yes, notice was served, but nobody appeared.
Yes, sir.
So, we will appoint one amicus curiae to represent the respondent number 2. Wait. Heard Mr. K.P. Pathak, learned counsel for the no, learned amicus curiae, and Mr. Locker learned additional opinion for the state respondent. It appears that notice upon respondent number 2 was served, but nobody entered appearance on behalf of the respondent number 2. Yes. The appellant stood convicted under section 376, 511 IPC, related section 10 of the POCSO Act.
354, your lordship. Conviction is under 354, your lordship.
And 10.
354 and 10.
354 IPC, related section 10 of the POCSO Act. Hearing of the respondent number 2 is mandatory in view of the judgment of this court in the case of Deepak Nayak versus State of Assam, and in view of practice direction issued by notification number 17 dated 15/3/2024. Accordingly, yes, Mr. Locker.
Povitra Soikia. P.
Povitra Soikia, Mr. P. Soikia is appointed as legal aid counsel to represent the case of respondent number 2. To represent the respondent number 2. Rest shall reflect the name of Mr. Soikia in the cause list and also furnish the relevant documents and the paperwork. No, also furnish a copy of the paperwork to him. List the matter on it. 11.
20 to 22, 20, 21, 22.
It is, I mean.
Lordship, in item number 20, Lordship, our senior counsel, Mr. T.J. Monto will appear. He is on another court, Lordship. He is on the leg.
Item number
20.
And in other matters?
Your Honor, in item number 22, Mr. B.M. Chaudhary will be appearing. Item number 22.
Is he available?
22, yeah.
Available.
Exactly.
So let Mr. Mahanta come. We will start.
Next.
Who is for the ED?
Mrs. A. Gayan is the lordship.
She is available.
She is available, lordship, but she is in lakes.
Okay, after some time.
Or my lord, can you
Another,
take enough?
another day may be fixed, lordship.
Why?
Next week or any other.
Why?
Next Thursday or next week.
As agreed by learned advocates of both sides, races are list the matter on
6 June.
6th of June.
6th of
June.
Lordship, item number 20, there is an interim order.
51.
51.
Okay, interim order passed earlier in item number 51 shall continue.
Item 23.
My lord, here, my lord, wife of the petitioner filed, my lord, the case under Domestic Violence Act, my lord, and the judgment and order passed by the learned trial court, page 35. And my lord, against this order, my lord, relevant portion, page 49.
What is the order? Where is the order?
Order part, my lord, the operative part by the trial court, page 49, my lord.
49
49, my lord,
of your petition.
of my petition, my lord. In view of the discussion made above and the decision reached in the foregoing points for determination, it is directed that the respondent is restrained from committing any of the domestic violence.
Want of jurisdiction. And this was the first FIR, my lord. On the same date, Rongia police station transferred the case to Dispur police station for want of jurisdiction. So, my lord, there was an exchange of FIRs between Dispur and Rongia on the same date. My lord, the relevant orders I have annexed at page 55, my lord, may kindly peruse.
No, that's all right.
Yes, my lord. My lord.
That will not serve your purpose.
My lord,
Uh,
now,
your
thereafter, my
first
lord,
FIR
once
is
again,
page number 33.
yes, my lord,
Second FIR is 65.
my lord.
And the other FIRs?
But subsequently, my lord, just for a moment, my lord, the first FIR which was initially transferred to Rongia was again retransferred to Dispur. So, my lord, now Dispur police station is holding two FIRs, my lord, the first and the second. And the third FIR is at page 78, my lord. Now, the complainants here in the third FIR are from Tihu and Patarkuchi. From Tihu and Patarkuchi, 78, my lord. And the case was registered by Mangoldoi PS initially. Subsequently, it was transferred to Dhula PS. And the fourth FIR, my lord, is at page 91. Now, this is the Dhula PS, fourth FIR. Third is was Tihu and fourth is Dhula PS. Now, the complainants here allegedly are from Mangoldoi. Your lordship will remember even in the second FIR, the complainants were allegedly from Rongia and Mangoldoi, which was transferred to Dispur for want of jurisdiction. And the first FIR which was transferred to Rongia was again retransferred to Dispur for want of jurisdiction. So, my lord, the nature of allegation is verbatim the same.
The pair in this writ petition is to club together all these four FIR.
My lord.
That is your pair.
My lord, let it be investigated by one agency. One agency, my lord, be the
So now, who has been investigating the FIRs?
My lord, the
It's
first and second
Assam Police?
FIR is being investigated by Dispur police station. The third FIR is being investigated by Tihu police station. And the fourth FIR is being investigated by Dhula police station. My lord, may kindly come to page 96 once in the objection petition, my lord, filed by the state. I want to place before your lordship the stand of the state. And it starts at page 95, last para, page 95 in the objection filed by the state, last para. Page 95 of the objection petition. Objection.
Okay. Objection petition filed by respondent number.
The response, state respondents, my lord, 1 and 2. No, filed by the state. Precisely. 1 to 6, my lord, to be precise.
Huh?
It was filed on 19/9/23. Filed on 19/9/23.
Reply to petition idea. But that affidavit is not available on the record. When, yes, madam, when you have filed the affidavit?
Your lordship, we have filed it on 29/23, your lordship.
When?
29/23. September 23, your lordship.
September 2020. Twenty 29 or 20?
September 29.
Yeah. 27.
By state.
As
by
state, yes, lord.
Yes, page number.
95, my lord. Last para. Lordship got it, my lord.
Pair number?
Last para, my lord. F, last para. F. 95.
Yes.
The deponent further begs to state that the contents of both the FIR, that is Dispur PS case number 2098/22 within bracket first FIR and Rongia PS case number 596/22 second FIR, are based on the same cause of action, having same place of occurrence, but the complainant belong to different parts of the state. Since FIRs fall under the district of Kamrup Metro at Guwahati, hence both the FIRs have been transferred to its original place of occurrence, that is Dispur, with all the documents and case diaries. Similarly, in the second FIR, the complainants were from Rongia and other parts of Mongoldoi and other parts. And in the first FIR, my lord, it is not clear where the complainant had received the training, although the complaint was filed in Dispur. Now, this is the stand of the state, my lord. In addition to that, my lord, may kindly
No,
come
that
to-
is only in respect of FIR number 1 and 2.
Yes, my lord.
In respect of FIR number 4 and 5.
Yes, my lord. Even in respect of 4 and 5, my lord, at page 97, there has been a statement made by the state. Last para, my lord. Page number 97, para E, last 4 lines. The officer in charge, Tihu police station, at the time of registration of FIR was not aware that multiple FIRs have previously been registered at different police station with similar letter of complaint. And my lord, at para C above, at page 97. At page 97, my lord, para C. That as regards to a statement made in paragraph so and so of the writ petition, the deponent begs to state that the complaint did not disclose the fact that FIRs have been previously registered at different police stations regarding the same incident given. So, my lord, even this is the admitted position of the state that the incident are of same nature, arising out of the same transaction. my lord. So these are the admitted position.
Where is the judgment of Supreme Court of which you have relied upon?
My lord.
Yes, so what is your stand? You are for respondent number?
7 to 10, Lordship.
7 to 10. So
Lordship-
what is your stand?
Lordship, the place of occurrence, date of occurrence, and informants are also different in each FIR, Lordship. And so the cause of action also arises in different places in different days, Lordship. So, as the petitioner has stated that the FIRs are same, but as the petitioner.
No, these allegations are same.
Allegations are, but cause of action and other informants and other versions are all different, Lordship. Even a place of the place where they have given training are also different, Lordship. Moreover, Lordship, even we have annex 109, page number 109.
109
of our affidavit in opposition, Lordship.
109.
109. This is a certificate, Lordship. The certificate given by Azitax Venture Private Limited, Lordship. Here the signatory as say Hazarika IAS, even those persons are not being made party in this writ petition, Lordship.
Pardon?
Those persons are not being made party in this writ petition, Lordship.
Who are the persons?
In annexure A1, page number 109. So these are the certificates given regarding the successful clear assessment of skill development program project. So here, where Director of Azitex Spencer Private Limited had signed on the certificate, and one S.J. Hazarika IAS of Labor Commissioner, they have also signed, but the writ petitioner did not make party to the both signatory of the certificate in this writ petition.
No, Omar Zatek Hanekor, he has been made a party.
No, this S.J. Hazarika project. Now, what he is trying to convince your lordship is there are 50 persons who had joined the letter cause of action for filing the letter of complaint. And out of those 50 odd persons, the address, name and address of the complainant against whose name the FIR was registered was available with the petitioner. And my lord, may kindly come to page 35 once, it will be clear.
Page number
35. of my writ petition.
Yes.
The complainant number 1 at page 35 down below, Sri Modan Kolita. Phone number ending with 38. And my lord, the address is provided at page number 33 in the formal FIR. This is how we got to know the address, and rest of the complainants, my lord, at page 36. But we kindly come to page 36. Number 3, this is some Yusuf Ali with phone number. No address was provided, which is why, my lord, we made a specific prayer, interim prayer, to furnish the details so that we can serve a copy of the writ petition. And this point was earlier urged before this honorable court. But may kindly come to page 23 once, prayer portion. Page 23, prayer B. A writ of mandamus be issued directing the state respondents to forthwith disclose and furnish all material particulars of the other complainants in all 4 FIRs respectively to the petitioner hearing. Leave be granted to the petitioner to array the other complainants whose particulars are not available in the 4 FIRs respectively, if so directed by this honorable court. So, my lord, we appraised this honorable court regarding the non-availability of the address, what constrained the petitioner from serving the copy of the petition and making them a party because of the non-availability of the address. So, my lord, this issue was raised at a very nascent stage, and my lord,
thereafter what happened?
Thereafter, a coordinate bench was of the opinion that we will decide it later on. We'll proceed with the hearing because after all, the nature of allegation will remain the same. And if required, we will make them a party, but not at this stage.
Lordship,
Yes.
Lordship, I'm not on the point that we are giving a. Lordship, I'm not on the point of not making party to an informant. I am just submitting before your Lordship that on the page number 109, that is the annexure A1, at the below, there is one labor commissioner, that is S.J. Hazarika. He have also signed it. So my submission before Lordship that this writ petitioner did not make party to that signatory, Lordship. There may be many informant. It is difficult to make party to all of them, Lordship, but they did not make party to this labor commissioner who have signed in this certificate, Lordship. No, the question is whether any prejudice will be caused in view of the nature of the prayer being made in this petition.
Lordship,
If the Labor Commissioner is not made a party here, because no relief is
Yes.
being sought against him.
Lordship, one more. Lordship,
So where is the question of prejudice?
actually, Lordship, one person, Pradeep Kolita, he have filed an RTI application, Lordship. RTI application before this ABOC WWB. So, in that RTI, he have given various questions regarding this training and all. But in that RTI, it was clearly mentioned as per official records, Azita Venture was not empaneled as training service provider for phase 1 development training, Lordship. So without making any party to this party to the signatories, so it is this petition is liable to be dismissed on non-joinder, Lordship. And moreover, the place of
No,
occurrence.
in all cases of non-joinder, writ petition cannot be dismissed.
Place of occurrence, date of
No,
occurrence.
whether any relief is being sought for against that person.
And moreover, Lordship, the place of occurrence, date of occurrence, time and informant are all different, Lordship, meaning different cause of action. So coming up, the prayer of the writ petition must be
Yes, must be.
But it must be dismissed because different informants are there, different cause of actions, and different states are involved in over here, giving different training to different areas of the Assam. So,
But the nature of allegations are in all the cases same. Then the parties against whom the allegations are made are same. Are you denying that?
oh, Lordship. Like, actually, cause is same, Lordship, but the timing and
only the place of occurrence is different.
place of occurrence
And the
informants of
informants are different.
different, Lordship.
But nature of allegations are same.
Same.
And the person who allegedly committed the offense are same.
Yes, Lordship.
Yes, Mr. Das, in which cases you have which paragraph of the
Just
judgment
to
you have
advise
relied
your
upon?
lordship on fact on one issue, my lord. He is also representing respondent number 8. 7 to 10 precisely. He is also representing respondent number 8. Who was the complainant at Rongia police station, which was transferred to Dispur police station for want of jurisdiction, and he did not challenge that order. He has no grievance. He has not raised any grievance of the Rongia PS case being transferred to Dispur. So, my lord, what food goes for geese goes for gander, my lord. What would be his standpoint on with regard to respondent number 8?
Okay.
Yes, my lord. And so far as the judgments are concerned, my lord, one of the first judgment which I am relying upon.
This is Pranabjyoti Burman.
Yes, my lord.
Yes.
But
This
here,
paragraph you
even
have
in
relied
this
upon.
case, even in this case, at page 44, placitum B, C, page 44, second page, my lord, page 44, placitum B, C, placitum C. The CBI objected to the said prayer on the ground that although both the cases seem to be similar and identical, but the complainant, place of occurrence, and sections of law mentioned in the FIR are different from each other. So exactly what is the case being argued by my learned friend? My lord, considering this prayer, my lord, ultimately it was decided that at best the second FIR can be treated as a statement under 162. May I take your lordship to the judgment, my lord, at para 6.
No, where is the finding of the court?
Yes, my lord. My lord, the finding of the court relying upon two judgments, paragraph 15, relying upon TT Anthony, paragraph 15 and 16, Babu Bhai. My lord, these were the two judgments which were relied upon. And ultimately, the finding is at page 17, my lord. in light of the aforesaid settled propositions of law and applying the test of sameness, if we read the two FIRs together, it becomes clear that both the FIRs have been filed referring to the same incident of the year 2010. In Anju Chaudhary, it has been held that where several offences are a part of same transaction, the test of sameness has to be applied, whether they are so related to one another on point of purpose or cause and effect, so as to result in a one continuous action. It has been held that second FIR in respect of same offence forming part of same transaction as complained in the first FIR is not permissible. Commencement of the reinvestigation after completion of previous investigation pursuant to the first FIR and filing of report based on such investigation before the court is not permissible. Further, it has been held that inbuilt safeguards provided under the CRPC are principles akin to double jeopardy, fair investigation, and prevention of abuse of power by the investigating agency. Paragraph 19, madam. In view of the findings and discussions above, this court is of the opinion that instead of quashing the second FIR, it would be suffice if the second FIR is treated as statement under section 162 CRPC. Accordingly, it is directed that the learned trial court will proceed with the matter by clubbing both the cases together by the same court by treating the second FIR as statement under 162 CRPC. Well, this
Any
has
other
followed.
judgments?
The judgment has followed Babu Bhai Malot, 2010 12 SCC 254.
What is the relevant paragraph here?
Malot, relevant paragraph is at page 263, Malot, paragraph 15, again referring to TT Antony.
Yes.
Paragraph 15, Lordship got it, Malot? The court further observed as under referring to TT Antony, a just balance between the fundamental rights of the citizens under Articles 19 and 21 of the Constitution and the expansive power of the police to investigate a cognizable offence has to be struck by the court. There cannot be any controversy that subsection 8 of section 173 CRPC empowers the police to make further investigation, obtain further evidence, both oral and documented, and forward a further report or reports to the magistrate. However, the sweeping power of the investigation does not warrant subjecting a citizen each time to fresh investigation by the police in respect of the same incident, giving rise to one or more cognizable offences consequent upon filing of successive FIRs, whether before or after filing of the final report under 173(2) CRPC. It would clearly be beyond the purview of section 154 and 156 CRPC, nay, a case of abuse of the statutory power of investigation in a given case. In our view, a case of fresh investigation based on the second or successive FIRs not being a counter case filed in connection with the same or connected cognizable offence alleged to have been committed in the course of the same transaction and in respect of which pursuant to the first FIR, either investigation is underway or final report under section 173(2) has been forwarded to the magistrate, may be a fit case for exercise of power under 482 or under 226, 227 of the Constitution. So, even if the investigation is under the final stage, this was what the Supreme Court has observed. Next relevant para is at page at para 21.
No, where is the finding?
These are the observations which were passed in Babu Bhai Malot. The case was a bit different from what was placed at para 15 and 21. These are the propositions of law which was upheld. And the finding is at page 46, para 46, my lord. Thus, the order of the High Court requires modification to the extent that the charge sheet in both the cases or any order consequent thereto stand quashed in case of the accused could not get bail because of pendency of these appeals before this court. It shall open to him to apply for bail. So and so, in case such an application is filed, we request appropriate. So, my lord, this is the
finding.
Yes, my lord.
And this order of Dusani?
Yes, my lord. My lord, the relevant paragraph is at page 31, para 31, my lord, page 36. Para 31, page 36.
Yes.
The court held that there can be no second FIR where the information
No,
concerned.
that observation was made referring to TT Anthony.
Yes, my lord.
Yes.
Then again, TT Anthony referred, para 33, 32. Babu Bhai referred in 36, my lord. And then 39, my lord. 39, Placitam C. The manner in which the petitioner has been subjected to numerous FIRs in several states beside the Union Territories of Jammu and Kashmir and on the basis of identical allegations arising out of the same television show would leave no manner of doubt that the intervention of this court is necessary to protect the rights of the petitioner as a citizen and as a journalist to fair treatment guaranteed by Article 14 and the liberty to conduct an independent portrayal of views. In such a situation, to require the petitioner to approach the respective high courts having jurisdiction for quashing would result into multiplicity of proceedings and unnecessary harassment to the petitioner who is a journalist. And my lord, at page 49, para 61.5.
Yes.
Referring to TT Anthony, my lord, the following FIRs are quashed following the decisions of TT Anthony that successive FIRs complaints founded on the same cause of action are not maintainable. This is what was held in Arnab Goswami.
Okay. In the other judgment?
Yes, my lord. My lord is taking Krishna Lal Chawla or Mohammad Zubair.
Yes.
Well, we'll continue.
But I have a small prayer, Lord. But Lordship may kindly accommodate me for the Lordship may, if possible, kindly give me an opportunity tomorrow, Lord. Tomorrow, Lord. Lord, the submissions I just would like to submit, Lord, the Babu Bhai or the TT and the case, Lord, Babu Bhai and TT Anthony, those are, Lord, TT Anthony is a police firing case and Babu Bhai is a public move, Lord. It was a case, altercation took place between two members of two communities. In fact, Lord, the offenses are categorized and 5 categories has been drawn up, and this the financial fraud that has been taken into a separate category, my lord, and specifically the Honorable Court has said that TT Anthony will not come into the rescue in those cases. I'll place that, my lord. I'll place whatever is there, my lord, because the Babu Bhai has been, my lord, and TT Anthony has been relied. Those are mob violence case, my lord, police firing case, my lord, a lot of cases are there.
No, that's all right. Facts may be different, but the principle of law laid down in those cases.
That is what, my lord, I would like to place that the financial, my lord, the frauds that has to be taken in a separate legal law. Ultimately, the categories.
But Mr. Das has pointed out some of the paragraphs and points in your affidavit where you have admitted that allegations are almost identical in almost all the affairs.
But I'll place, my lord. I'll place.
Moreover, it was the stand of the state to transfer the Rongia PS case to Dispur, my lord. And what would be the stand of the state if this argument is to be accepted by the court, my lord? The state cannot blow hot and cold in the same breath, my lord.
No, we are not.
Had it been a case, my lord, that the Rongia PS case would not have been transferred to Dispur, then this argument, my lord, could have been of some relevance, my lord.
Offenses are leave the matter tomorrow as parted.
Offenses are different. Witnesses are different, my lord.
Okay. Heard Mr. S. Das, learned counsel for the petitioner, and Mr. Your good name, please? PD. Pardon? PD. Yeah. Learned counsel for the respondent number 789 and Mr. Dina, learned senior government advocate for the respondent number 12.
126, my lord.
The state respondent.
126.
126. Heard in part, please the matter.
Yes, 126.
13456, not 2.
Not except 2. 126 except 2.
Okay, except 2. And who is for respondent number 2?
two concerns.
Gogoi.
Two points.
Okay, Mr. B.B. Gogoi, learned additional entity for the rest of the number two. Heard in part, recessal is the matter tomorrow.
I can
So
agree.
further hearing.
My lord, I'll continue tomorrow, my lord.
Ah,
Yes, yes.
The state, response number 2 is state. I can appear for that also.
you can appear.
Yes, yes.
Okay.
State. For the state.
Okay.
All
It will be adjourned for today. Senior
Item
Against
number?
Council is not well.
Item number
25.
25, we have already taken up on the matter. Huh? That's it. That's it. Matter to So 35 क्या होगा?
মোটা কল করেন নাই Item 9, my lord.
This
He has
is
not
the
appeared, my
particular,
lord.
25.
25. oh.
Yes, you were appearing for
AK Zain.
AK?
Zain.
Your good name?
R Doctor.
On the
Mr.
pair
Cox.
being made by Miss R. Doctor, Learned Counsel, appearing on behalf
বলছি
of
ইমান আমার
Mr.
পয়সা কবুল নয়
AK Jain, Learned Counsel for the petitioner. Traces shall list the matter on when?
Any sort of thing we can. Highly obliged.
Yes. Here, my lord, he has not appeared, my lord.
But
Not
as per
appeared.
my instruction, my lord, he appeared, my lord, 3 occasions. Even today itself, he's in the, my lord, in the police station.
That we do
So
not know, my lord.
regarding this, my lord, I have to file a affidavit otherwise, my lord.
Oh,
My lord, because he specifically stated that he has appeared, my lord, on 3 occasions. And today itself also, my lord, he's in the. police
Diary is
station.
up to
Right now.
21/4, my lord. 21/4.
Yes,
And
sir,
today that
If we go away, Learned additional PP submits that he has not, no, he has received the case diary, but the same has not been updated since 21,
21/4. No,
21/4/2024. Accordingly, it is provided that Mr. Gogoi shall produce the updated case diary before this court on when?
interim June or
On 5th June.
Till then, interim order pass earlier shall continue.
deep load.
Having under 34.
34 to when क्या आएगा?
Seriously, lordship. Okay, kindly pass over the matter for the time being, lordship.
Why?
My senior is in Lex, lordship.
Who is your senior?
A guy.
Having item 15 and 16.
May I please?
Yes.
Lordship, Lordship, my senior is about to argue, but a part of matter is going on court number 3. So he won't be able to argue today, Lordship, any that
Okay. On the pair being made by Miss
A Pine.
A. Pine, Learned Counsel appearing on behalf of Mr. J. Pine, Learned Counsel for the petitioner, appellant. Recessal is the matter on
13 June.
13 June.
Obliged.
Obliged, Lordship.
Having item 23. May I please, lordship?
yes.
Question is that appeal is filed on 1/10/2019.
Ricardo can furnish a copy of the same well in advance to Mr. Gogoi. And also to Mr. S. Visas. Well in advance. List the matter on
18th June.
Solution.
28.
My pleasure, lordship.
Lordship, my senior counsel is having some health issue, Lordship, and therefore I'm praying for an adjournment for the day.
Who is your senior?
Mr. A. Sahad. Mr. A. Sahad.
Yes, sir. What is your name?
M.H. Ali.
Mr. M.S. Ali, Learned Counsel for the Learned Counsel appearing on behalf of Mr. A. Sahad, Learned Conducting Counsel for the petitioner. Price for an adjournment. As he is as conducting counsel, Mr. Sahad is suffering from some health issues. Here is accordingly allowed. Recessal is the matter on
13 June. Item number 31.
Or less, Lordship.
Item 31.
Hey, please, Lordship. Lordship, may kindly look, take up order dated 24/1/24, my lord. My lord, in this case, a notice was served on the respondent and the respondent did not come and the matter was fixed for hearing. However, my lord, it's a POXO case. So perhaps, my lord, an amicus needs to be appointed for the respondent number 2.
what is that, AD? Mr. Gogoi, can you assist the court by appearing for the respondent number 2 in this petition as amicus curiae?
My lord is addressing me, my lord?
Yes,
Yes, I'm ready, my lord. No issue.
Savita Devi Saha. Who is Savita Devi Saha? Informant?
Informant, my lord, is
Palua Saha.
Talwa Saha. I'm checking the evidence, my lord. Informant is Talwa Saha. Must be the wife of the informant.
No, that
Wife of the informant.
first is as Nawaz, the learned counsel for the appellant and counsel for the appellant. Office note dated. What is the date?
My lord, I'm not sure the date because this came up in the last order itself, my lord.
Office note dated 22/1/24 indicates that AD card has been received. AD card of the notice issued to the respondent number 2 received back with a signature. But the respondent number 2 remain unrepresented today. In view of above, it is provided that Mr. D. Gogoi, learned advocate, be appointed as amicus curiae, no, as legal aid counsel to represent the respondent number 2. The rest shall furnish. No, rest shall reflect the name of Mr. D. Gogoi, learned advocate for the advocate as legal aid counsel in the cause list and furnish relevant papers to him well in advance and list the matter on hearing it alone.
18 to 11 to 11, because my lord, this person is in jail for 2 years and 7 months. 11.
Always, ma'am.
I'm deeply offended.
36, item 36.
Maybe it is also. Last occasion, Roxy was shot for some judgments.
Which judgment?
Judgment about, they said about 161 statement, about embezzlement.
Pardon?
Embezzlement. If it is not stated in the 161 statement, it is stated in the, before the court. Any judgment. This is one latest judgment of 2024. Prayer number 26 and 28. Darshan Singh versus State of Punjab. 24 live loss. Recent judgment, 3 months ago. Twenty-six. May I read?
Yes.
If the PWD has failed to mention their statement under 161 CRPC about the involvement accused, their subsequent statement before court during trial regarding involvement of that particular accused cannot be relied upon. Prosecution cannot seek to prove a fact during trial for a witness which such witness had not stated to police during investigation. The evidence of that witness regarding the said improved fact is of no significance. And it is in prayer number 28 is given in detail.
No. Here it is stated that the evidence of witness regarding the said improved fact is of no significance.
Prayer number 28 is given in details.
Prayer number
28.
No. When it will amount to contradiction here. In 161 statement, he has not stated about involvement of the accused. In this case.
And then this what in 161 statement here he has not stated.
He has not stated about the accused person.
About something also. 28 I will this.
No, that's all right. Let me explain. In 161 statement, this PW, one PW has stated nothing about the nothing about involvement of the accused. But in his statement before the court, in his evidence before the court, he stated about the involvement of the accused. So these two statements cannot be reconciled. So that amounts to contradiction. But in our case, whether it would amount to contradiction, that was my question.
It says paragraph 28. However, the testimony of PWD suffers not merely from technical imperfections. They are glaring omissions and improvements that have been brought out in a cross-examination. This cannot be attributed to the illegitimacy of.
In this case, the contradiction is glaring. But in our case, is it glaring?
Yes, because in the 161 statement, they have not stated that there is wound in the stomach or in the other part of the body. All here in the deposition, they have stated.
But you see, the father of the victim, he stated that he had seen mark of injury over the neck. And that injury is corroborated by the PM report. where doctor found that he also found this mark of injury over his neck, over the neck of the victim.
There is a mark in the neck.
Yes.
It is not a tie knot.
Maybe.
Maybe, but it is
But
there.
there was mark of injury.
But there is no. But in a person report, there is no external found. It is only a mark, not wound.
Yes.
It is a mark, not wound. No, in a postmortem report, this is that there is no external found. So it is in a PM report. This is I have seen this is not a tie knot, and the cause of death is different. May I read that is paragraph 28?
No, 28, that's all right. There is no quarrel in the proposition laid down in this judgment.
And another thing is Parbat Singh has a state of Madhya Pradesh. Parbat Singh. Next one. Para 14.2, 15. As observed here in a statement under 161 CRPC, she has never stated that accused Santosh and Rakesh has caught hold of Balkishan, but stated that appellants having told to run away as other persons have broken. In facts and circumstances of the case, there are material contradictions, omissions, or improvements. So far as the appellants having originally accused of 215.
That is the question of when the contradiction or omission or improvement would be material.
They are not stated in the IOS stated, your lordship, humble submission. The IOS stated that yes.
No, that we have already perused, and you have also pointed out.
They don't know. They have not stated before the.
But my question was whether it would amount to contradiction or not.
There's an improvement. What they have.
No, every improvement or every omission will not amount to contradiction. That is settled law.
No, 3 years after, 4 years after the incident, they've improved. There is exaggeration on their part after 4 years because on 2015 the incident happened and the evidence taken in 2018 or 19, suppose 18, 19. After 4 years, there's lots of improvement. Nothing was stated in the 161 statement.
160?
One statement, nothing was stated. Only some leading point. And
nothing was stated.
You have stated that at a time of as part of this PW1, he has stated at a time of marriage, he has taken money at a time of marriage, 5 years. At a time of marriage, he has taken money.
And although there was demand of dowry on earlier occasion, there is no live link. And the victim died of her stomach ailment. So these are the points you have raised before this happened.
And soon before that. And PW4, I have PW4. The page 21. Sorry, PW5. Page 21.
I have seen it.
Here in the below, the information my father, the deceased is my elder sister. I know the accused person. I have seen him in dock today. The incident has taken place in 2015.
No, Mr. Gogoi, not necessary to read.
Because he has stated after the mother, she stayed in Lakhimpur for some months from Bihar. But father said that the appellant has taken brought the victim from Bihar to Jagiroad. But here he said that he stayed there in Lakhimpur. Since her husband, the accused had business in Jagiroad, he used to spend time in both the places. Therefore, in 2015, my mother, not the accused, his mother went to Bihar contradictions. My mother went to Bihar to bring her back.
Those are not on material point.
And she was brought to Lakhimpur because
Those are not on material point. This contradiction will not help you.
because what is the demand of once upon a time, Lakhimpur there.
That's all right. Okay. Okay. The other point is, you lived in your rented house with your wife on the relevant date also. Now the question is, how you were to explain how your wife suffered demise. That I have pointed out this judgment is Trimukh Murti Marukon, Trimukh Maruti Kirkon. Have you brought that judgment?
On the last occasion, I heard Parvati. I heard Parvati.
No. Trimukh Maruti Kirkon.
Maruti?
Kirkon. Probably find out. Trimukh Maruti Kirkon. Trimukh. Kirkon. K-I-R. K-O-N. Kirkon. He marked in that level. Okay. SCC online to say.
Rossi, sorry, I'm heard Parvati Devi.
No.
And Rossi, there is no other witness because the room is only 12 by 12 feet, one room where he lives. Is a Sally next other family resides. If there is some physical, there will be definitely they will hurt. No other witnesses said anything.
No, maybe, but there. What's that? So either we can take it up on 28 or 30.
20.
28.
28. 28.
28.
20.
List the matter. Recessal list the matter on when COVID? 30. 30. 30 or 28? 30. 30. As part 30.
Obliged.